25th day of June 2005, we bring you a lecture entitled The Protocols of Liberty, presented by Taj Tarik Bey and Nature L. Bey.
Islam. This is our part two of continuation of a lecture we did, Protocols of Liberty, Protocols of Liberty 2. And actually there's nothing complete in any of the lectures because it's an ongoing study. And the other issue is it's sort of like a book that's unwritten because not only you're reviewing history and law, you're also making history and law. So you're actually living history and also the evolution of government here in North America, being an important component part. One of the issues that's very, very important for the natural people to understand about this thing is how this came about, what you're doing here, why are we even discussing this at all? And because, for the most part, the Moors in North America have been disconnected from history, disconnected from law and government, they don't necessarily recognize that certain things that they reject relative to his concepts is equal to throwing the baby out with the bathwater. So one of the important concepts of interest for you to understand is your reconnection to this government, the legitimate government, as opposed to what you see and think is, quote unquote, the government. And so for these things to be clarified to you, is necessary for you to understand protocols or how you are to act or proceed in your relationships with persons in government in order to preserve your rights. Rights that you have that you know of and rights that you have that you may not have known of. So we're going to do a quick review of history as history and law goes together, and I'm going to go from an old book roughly from 1928, 1931 area. And as you know, as later as our people began to read, they began to edit and alter the books even more. But this little book deals with the story of the Inquisition. Now first want to note that the Inquisition was initiated for one purpose, and that was to bring into check or to stagnate and to disrupt the Moors, or the Moorish Empire, which ruled the world, which is essentially the people now call themselves in North America, Negro, Black, and Colored, who don't know that part of their history, which is maintained in secret societies called Masonry, Skull and Bones, Jesuits, Knights of Columbus, Ku Klux Klan, Knights Templars, etc., etc. The great secret is you, which is why they also wear your fez. So it's important to understand these symbols. Now I'm going to read one of the chapters, part of the chapter, the expulsion of the Moors. Following the expulsion of the Jews from Spain came the banishment of the Moors. The same remorseless bigotry, perfidy, and cruelty characterized the last as had characterized the first. The Moors had been in Spain since the 8th century. They had given that country its most brilliant period of mental and industrial development. They had not persecuted the Christians, but their power through internal dissensions and the ascendancy of the Orthodox party, thus checking intellectual growth, had been weakened, and their dominions gradually passed into the hands of the Christians. Their rule came to an end with the surrender of Granada in 1492. No faith was kept with the victims. Granada had surrendered under the solemn guarantee of the full enjoyment of civil and religious liberty. At the instigation of Cardinal Ximenes, that pledge was broken. The atrocious cruelty with which these poor people were treated after every solemn promise had been broken by the Catholic party is a grievous blot on the memory of Ferdinand and his successors. A pragmatica was issued at Seville, February 1502, setting forth the obligations of the Castilians to drive the enemies of God from the land, and ordering that all unbaptized Moors in the kingdoms of Castile and Leon above the age of infancy shall leave the country by the end of April. And some were tortured, some burned, and all were terrorized. After 1526, no Mohammedans or Moors were left in Spain who had not been converted to Christianity. Immense numbers of them were baptized by force, but being baptized, it was held that they belonged to the church and were amenable to her discipline. And that discipline was administered by the Inquisition, which during the rest of the 16th century subjected these new Christians, or Moriscos as they were called, to the most barbarous treatment, and the genuineness of their forced conversion was doubted. It therefore became the business of the church to inquire into their sincerity. That's relative to history and civilization. And Philip II, in 1566, ordered the Moriscos to abandon everything which by the slightest possibility could remain or remind them of their former religion. And they were commanded under severe penalties to learn Spanish and to give up all their Arabic books. They were forbidden to read their native languages, or to write it, or even to speak in their own houses. Their ceremonies and their very games were strictly prohibited, and they were to indulge in no amusements that had been practiced by their fathers, neither were they to wear such clothing as they had been accustomed to, and their women were to go unveiled. As bathing was a heathenist custom, all public baths were to be destroyed, and even all baths in private houses. There's more, but that's basically how they brought our people to the state of what you call this ghetto Negro state, by killing the culture, literally. And the continuation of the Inquisition practice is what initiated what you call colonialism in the Western Hemisphere. And the practices against our people that our people call prejudice, double standard law, racism, whatever names they may give it, which are all misnomers, are a continuation of the Inquisition. And if you don't know that, you can't understand the history, nor can you understand the politics. So in order to understand where you are now, you must understand what's being initiated against you. And this same policies were also mentioned by William Lynch, and also thereafter in 1724, where the drafting of the Christian black codes came into play from the church. We will continue with some principles of protocols or reclamation of both your lost estate and your birthright, with processes of communications and documentation relative to dealing with the occupational government. Therefore, the protocols of liberty are in order. Grand Sheik Nature.
Salam.
Salam.
Out of the many lectures we have been doing, all in the nature of reclamating or reclaiming our lost estate and our in full life status, this lecture is Protocols of Liberty Part 2. To get into the nature of Protocols of Liberty, we have to understand what is actually taking place. What is the application of what we are doing? What is this whole movement about? We was told that we was outside the constitutional fold of government. Understand what liberty is? I'm going to read the definition of liberty out of the Black's Law Dictionary, 4th edition. Freedom, exemption from extraneous control, freedom from all restraints, such as justly imposed by law. Ex parte, freedom from restraint under conditions essential to the equal enjoyment of the same right by others. Freedom regulated by law. And one thing we have to understand is you have different terminology and different concepts. When you hear the word by law, that's actually a legal definition. You have at law. At law and by law is two different things. We're going to get into the nature of what these mean, because they all have a classification of a status when you're dealing with the tribunal system. And all depending on what terminology you use classifies the venue or maybe even the status of one who is bringing the petition. The power of the will to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from other persons. The word liberty includes the comprehends all the personal rights and their enjoyments. It embraces freedom from duress, freedom from governmental interference in exercise of intellect, in formation of opinions, in the expression of them, and in the action or inaction dictated by judgment, freedom from servitude, imprisonment, or restraint. The rest of the definition gets redundant, but we all have an understanding on what the nature of the word is. You have freedom, you have liberty, two different things. Liberty specifies an exemption. Now let's examine the word exemption, because we might say, oh, we have exemption from certain things, or as Moors, we are exempt from paying taxes. Now we're going to examine that. Because the word exemption itself indicates a privilege. And we want to be very clear on that. When we say exemption, we're not being specific, because we're not saying what we're exempt from or who granted us that privilege to be exempt. So it specifies a classification once again, but it's not specific within itself. So it leaves it open. It doesn't mean it's a bad word. It doesn't mean it directly classifies us negatively. It's just not specific. And when we get into the etymology of certain things and the semantics of certain things in law, and that's another term, in law, we understand the do's and the don'ts. It's very important, because in our endeavorment of our freedom, certain terminology we use is not specific or be assumed negatively. So tax exemption, okay. Well, who gives the status of tax exemption? If you leave it as I'm tax exempt, you're letting the adverse party know that you have some type of exemption from government. Now, once again, it's not being specific, because what government? The average person's reality of government is de facto government, or people sitting in a building, or people sitting in colorful seats, disguising themselves as de jure government. We're not really challenging the terminology of what we're using. And this is one thing necessary in the protocols of liberty. So liberty itself has an exemption, or has a so-called privilege. And now, don't get me wrong, these dictionaries, even though this might be a law dictionary, it might be 30, 40 years old, 60 years old, or what have you, still does not mean that the nature of each definition is de jure. This is called a secondary reality. A common definition, which most people agree to, and even that is subject. Even that within itself is subject. See, we have to challenge everything. So it's not just reading the Constitution or reading some documents saying, okay, well, I have an exemption here, or I can use this, or I have the right to do this. If we don't understand the nature of what we're saying, it neutralizes the whole defense. So when we say tax exempt, who are we saying exempts us from the tax? That's not specific, so you see it automatically, you left it open. Because if you let them tell it, the de facto is going to assume that they're giving you some exemption which gives them the jurisdiction to regulate it. Which, by agreement, we're giving them the governmental powers to now judge the tort of what we're claiming. Once again, we're right in the jurisdiction. So, a better terminology to use would be non-obligated. Never exemption unless it's qualified. But on face value, it's going to be assumed. So the better terminology is non-obligated. And then still within that, you have to understand why you're not obligated to certain things. Because no one is exempt from tax on this planet. It's just that you have to know what you're paying taxes to, and who you're paying taxes to, and for what purpose. There's a cause and effect to everything in law. You have a positive and a negative force in law. You have a cause and effect. Polarized, 180 degrees per side, which gives you a full circle of equity, which we're going to get in also, because that's a misnomer. And the way it's being applied is a misnomer. Most of the things, the commercial activities, and everything we do is commerce. And we have to understand what that term commerce is. Because everything we do is based on commerce. But once again, everything has a classification. So the commerce we might be engaged in might be regulated by de facto government. And if we don't qualify certain things in the commerce that we're engaging in as far as contracts, then we allow ourselves to be regulated by de facto government. Now we did a lecture last week on how to live within the contracts. And the topic and the nature of that lecture is very vital to our improvement in our whole studies. Understanding that everything is based on contract and everything is commerce. We'll know that when adverse party or de facto government are dealing with us, they're dealing with us based on commercial regulations. Even when we make certain claims to Constitution or de jure, or I have the right to do this, I have the right to do that, they're regulating based on commercial activities. And we might argue that we're not indulged in commercial activities, but we are. And there's nothing wrong with that because we do have the right to contract. The Constitution is the contract that regulates commerce. So we have to understand how to use the Constitution in the forefront of the commerce or the commercial activities that we engage in. Because that's what sets the terms and conditions on how it's enforced, how the contract is enforced. Certain things like driver's license. We know it's a privilege. We might say, well, we don't need a driver's license. We have the right to travel. Understanding the nature of what we're saying. The way we understand our right to travel is how we actually apply it. and this is very important. Very important. A driver's license is a tax. It's based on a service. The driver's license also classifies us modern day because they're enforcing this to be a national identity. So it will have multi-different functions. The use of it will have multi-different functions now. It's not just, okay, well, I work for UPS and I need to carry cargo and this is how I eat, so I'm going to use this driver's license to bring in a so-called check at the end of the week. It's not just being used for that purpose anymore. So we have to examine that, but that is a tax. So we still might say, well, we tax exempt, so we exempt from that tax also. Once again, we have to get right back into who is exempting us from something. Because even you have a lot of de facto officials that has tax exempt status or exempt from a lot of things. They call it diplomatic immunity. Certain other classifications for them, they have it. So once again, you start talking about, well, I'm a diplomat, or I have diplomatic immunity as a Moor, once again, on face value, it will be assumed that you're getting some type of privilege from de facto government. They might say the same thing. They have the right to travel. Patriots say they have the right to travel. Patriots say they're exempt from certain things, exempt from tax. Based on their status will determine who they're exempt from. So the key of this whole nature of the Protocols of Liberty is based on status and how we apply it. Now going back to how to live within these contracts. We know the most common ways that we say, well, I'm going to reserve my rights when I deal with the contracts using UCC Code 1-207, not to be compelled to perform in any contracts that I can go into knowingly, willingly. Or we might use UCC 1-103 to try to keep it within a common law venue. It's absolutely necessary. But the polarity to those claims is knowing what our rights are that we're reserving. If we don't know the nature of our rights or where they come from, and if we're not exercising those same rights that we're claiming to reserve, it's automatically neutralized. And that's very important as well. Because a lot of claims that we make to reserving certain things, upon a challenge, we can't answer what they are. And we might not make those arguments in the right tribunals, which will automatically neutralize the whole argument. So going into, very briefly, the nature of the Protocols of Liberty is how to stay within the common law venue, i.e. federal venue, federal courts, for argument purposes. Because when we start saying reserving our rights, one way we're going to have to do that is by counterclaiming. And by enforcing our rights or enforcing the constitutional, protected, and secure rights in these federal venues, which the federal venues was put in place to deal with, i.e. federal question. Meaning, federal question, any question or any argument, any controversy deriving from the Constitution or based on any treaties or any engagements, international engagements put in place according to the Congress of the United States, is a federal question. And those type of questions only can be dealt with in a federal venue. So any claim we make to reserving our rights or enforcing our rights for argument purposes is only done in a federal venue, nowhere else. is every member or citizen of the United States Republic to enforce the Constitution, regardless of their knowledge or understanding of it. Ignorance of law is no excuse. Freedom is everybody's obligation. The fact that, yes, due to the Inquisition and due to the times of slavery between 1779 and 1865, we have usurpation of governmental seats. Elected representatives put in place to make sure that the constitutional venues and federal venues are carried out. That has been usurped. We understand that. But it's our obligation to get back into the constitutional fold of government. Form the class action, the plebiscite, and enforce it on a national level. Islam? Islam, you have the definition for commerce?
Yes.
You want to read that, Tom?
Commerce. 1, an interchange of goods, wares, productions, or property of any kind between nations or individuals, either by barter or by purchase and sale, trade, traffic. Intercourse between individuals, mutual dealings, and social life. Sexual intercourse, which is rarely used, but it still comes under commerce. Interchange, reciprocal communications, as there is a vast commerce of ideas. Barter, business, communication, dealing, exchange, and of course trade, traffic, etc. All these are commerce. It must be understood that government is in place to secure your right to commerce. Government itself does not produce a product. What you have due to Inquisitionists being in control of government, which is what you call today, those who are seeking sovereign right, you call U.S. corporations or the U.S., as distinguished from the United States Republic, which would be in reference to the organic law. What you have is the U.S. democracy or corporations in corporate obligation or contracts with corrupt politicians who institutionalized slavery under what you know as the 14th and 15th Amendments, which are unconstitutional, but this is where they created the artificial or the legal fiction of natural person into a corporate entity, or what you know as the nom de guerre, in doing the commerce. Whereas they bring in the obligation of the persons to have licenses, etc., what they must have, designated as any action that you do or any movement or trade that you might make would come under the auspices of excise taxation, whereas it would be implied that you're dealing with goods of manufacture and sale, which would include yourself, which would include your actual labor itself, meaning that the natural person would be listed as a corporate person or a corporation would make you liable under the laws of commerce. So issues of protocols of liberties would begin with you being very clear and making a distinction between the natural person and the corporate person, which is how they would be dealing with you, and make no assumptions in between. If you make assumptions in between and miss a clarification of concept when they're communicating with you, they will put you in the commercial venue, and when you do not object, they will proceed with you accordingly. And thereby, any contracts that you make with them or anything that you sign with them will be treated as a corporate operation. And everything that you do, including your labor, will be treated as capital gains. And again, remind you that the protocols of liberty will be such information, documentation, etc., that you will be using, or you may use or may construct in your operations or communications with the occupational government. being that you yourself are actually the organic or the original government subverted. The persons who are in the seats are what you would call the occupational government. Distinguished U.S., when you say U.S., you're talking about the occupational government. When you talk about the United States Republic, you're talking about the original organic political body established by 35 Moors and 20 Europeans in order to stop the wars between the Christians and the Muslims, which I mentioned to you in the Inquisition, which is how you got in the situation that you're in right now. So what you have is a battle of Inquisitionists being in control of the government or the seats of government for the United States, operating as if they're legitimate. You may or may not recognize their illegitimacy and may assume they have certain legitimacies of government that does not exist with them. Herein lies your argument of clarification of status. This, again, is the issue of the protocols. How would you proceed? How do you proceed? What is your status? What is the condition of your communications with them? The language that you use. So it became very important for the colonists to systematically adjust or change the language so that certain words that have original meanings that are important to your function in society would actually reverse themselves or be altered due to your use of those words and assumptions of them meaning something that they really don't mean. So a lot of these corrections must be made conscious to you, and you must make the effort in your consciousness, pardon me, outside of these types of classes to study so that you can join with your fundamental menu of information and knowledge a more clearer concept of what you're dealing with so that anything that may be said at this time or in the future doesn't go over your head. It's really elementary. However, due to the fact that people have been dumbed down, we already know that certain concepts may not be immediately understood. But the concepts that are being presented to you are vitally important for the preservation of your rights. Again, it's further stated that the obligation, as Grand Chief Nature said earlier, the obligation of the people, i.e. yourself, to be involved in securing of your rights is a duty and an obligation, not an option of information that you may have heard slightly or may not have gotten. For the injuries that you receive every day by abusive government, by persons who may be in seats of government, that persons that may be in quasi-government or sub-government agencies that may abuse the people, come absolutely from Inquisition powers. And so you must understand that, so you understand that when you're dealing with them, when they're acting untoward what they're operating from, as opposed to what you may assume that they're operating from. They're operating from a consciousness that is not necessarily displayed in the public arena. So when you see the conflict of how political figures operate, as opposed to the oaths of office that they take to uphold the Constitution and the rights of the people, when you see them in conflict, understand that they are consciously operating from an Inquisition venue. Absolutely. So don't call it prejudice, don't call it racism. They're operating from an Inquisition venue. Your duty now, in order to regain your lost estate, your rights, to secure them, is to come back into the construct or the constitutional fold of government. Outside of that, you can forget it. You're not going to be secured in your rights. So you must understand who is in operation here and why they're doing what they're doing. Not guessing, knowing why they're doing what they're doing. Until you understand that, then you won't understand the protocols of your liberties, securing of your liberties. Grand Chief Nature.
One distinction I would like to make is between public law and public policy. Now, when you deal with the public, dealing with the pub, which is the people at large, society, that is the de jure government. The people elect representatives to represent the interests of those inalienable rights secured and protected by the national Constitution of the land. That is pursuant to public law. You have what they have converted to, which is called public policy, or private law, corporate policies, corporate law, which is those policies that has been enforced by a legislative, de facto legislative branch of government based on state statutes and corporate policies, right back to the Inquisition. It's nothing but recycled codes from the Inquisition, painted to make you think that there's some type of liberty in them or some type of benefit in them, to get the people to agree to them or to make it a demand, which is their modern day of common law. And we want to examine that and get into the nature of that. So public law, according to the Black's Law Dictionary, is that branch or department of law which is concerned with the state in its political or sovereign capacity, including constitutional and administrative law, and with the definition, regulation, and enforcement of rights in cases where the state is regarded as the subject of the right or object of the duty. That's important. Including criminal law and criminal procedure, and the law of the state, considered in its quasi-private personality, i.e. considered in its quasi-private capacity, or capable of holding or exercising rights, or acquiring and dealing with property, in the character of an individual. That portion of law which is concerned with political conditions, that is to say, with the powers, rights, and duties, capacities, and incapacities, which are peculiar to political superiors, supreme and subordinate. In one sense, a designation given to international law as distinguished from the laws of a particular nation or state. In other sense, a law or statute that applies to the people generally of the nation or state adopting or enacting it. It is dominated a public law as contradiction from a private law, affecting only an individual or a small number of persons. Now, they mention the state in its political capacity. Now, most of us say, okay, well, we're not within the state's jurisdiction, or we don't have no ties with the state, or we're not residents of the state. Not saying we're wrong. But once again, that's not being specific. State just means a political body. State could also mean a condition. The word state has several different meanings. So we have to specify how we use terminology, especially when we're dealing with law, because it will very quickly classify us and then regulate us back based on the classification. Now, the state, the de jure state, the republic, of the geographical boundaries of the state, has a republican form of government. That has been overthrown as well. This is what we have to be totally aware of, because most of us do business within the geographical boundaries or territories of this country. But we're not referring to the state that we're doing the commerce in as a republic. That will automatically put it within the corporate or the public policies of the New Jersey state or Pennsylvania state statutes. Each different state is a political body, right? Now you either have the Republican side of that political body or the de facto side of that political body. That's why they start abbreviating the states, to get you away from the Republican side of that geographical boundary. which soon as they abbreviate it, and you agree to the abbreviation and start saying NJ or PA, now that was created exclusively by Congress, which Congress has exclusive jurisdiction over whatever they create. So we have to understand what's going on, staying within the common law venue. We fill out our location or correspondence for mailing purposes. We start abbreviating these states, it automatically takes it out of common law venue. That's number one. And then if the question is, well, where do you live? And we start putting down the abbreviations of these states, there's no longer a geographical boundary anymore. Now it becomes a corporation, an entity, a paper entity. So now you're saying you live within a corporation, a fiction. You're saying you live within color. So now the regulations of you becomes color. So it's not just necessarily reserving our rights or the claims. It's staying. We're going to hit on all topics of staying within the common law venue. Everything we do is judged accordingly to it, to its merits, the specifications of it. So that was public law. The law that's in the public interest, the people's interest at large, the people's inalienable rights. Now we're going to get into public policy. Not in the fourth, I think it's in the seventh. You have a seventh edition of it?
No, I have a 7.
Okay. Well, the public policies, the private policies are, like I said, those legislative enactments or amendments, and it's not really an amendment, but they added to colorably, which that's why I'm using as amendments, but they're mainly the state statutes, the annotated of the state. Those are more public policies. AT&T is a corporation. They have bylaws. They have rules and regulations. They have do's and don'ts. Those will be more public policy. McDonald's, another corporation. And for example, the state of New Jersey, it has nothing to do with the geographical area of New Jersey. That is a corporation. That is a corporation. So any rules, regulations, or what they might call laws of the state of New Jersey has nothing to do with the Republican form of government. It's public policy. All based on the Inquisition. Their modern day Inquisition. That's what it is. Modern day slavery. Political slavery. Because law does not compel performance. Anytime we compel to perform against our will, that is a form of slavery. Don't think that it's not. If somebody regulates our freedom of movement, that's automatically slavery. Slavery has different degrees. The fraud of granting somebody what they will call a privilege, which in nature is their right to do, is fraud, and that's a form of slavery. And it's in the nature of fraud by inducement. Because now they're inducing you to do a criminal act because it's against nature. So it's not just them doing something against nature anymore. Now they're inducing you to do something against nature. That's what neutralizes it on their part, because now they say that involuntary servitude is prohibited. So So they're saying they need your agreement, and they're saying with your agreement is now legal or lawful, which is fraud, because it's an unconscionable contract. Because consciously you would never have made that agreement if you knew that you had a right to do it in the first place, and they had usurped that right. You wouldn't have done it. And that's what most of these so-called privileges is based on. It's based on fraud. The commerce alone is based on fraud. We have a right to feed our family. We have a right to go to work. That's commerce. We have more of a right to do that than anybody else. We say this is our land. But the thing is fraud. Those contracts that we sign in and engaging in is fraud. And being it is fraud, and we might not understand it fraud, it creates a condition. It creates a condition. Now, we get caught in limbo because we really don't want to engage too much in it, because we're trying to protect and secure our rights. But at the same time, we are forced, we're coerced to deal with it because we still have to make a living. Now, if we measure our judgments, if we reason with authority and do everything according to the Constitution, then we're not waiving the common law venue, and we have every right to take those measures to reserve our rights in those contracts and still engage in commerce. So for example, if you use a driver's license, understand what it is and what is it used for. And also understand who can regulate it. If you're using a driver's license for what it is, because driver means one who indulges or engages in interstate commerce, that's what a driver means. Driver means that you're getting compensated, or so-called getting compensated, to direct a vehicle for pay. That's what a driver means. And the privilege, or the license, is the privilege part of it, which means someone is giving you permission to make money steering a vehicle or automobile. That's the fraud behind the driver's license. It has nothing to do with traveling from point A to point B. And they cannot regulate one traveling from point A to point B. If one is not indulging in interstate commerce, their right to travel cannot be regulated by anyone. So those who use the driver's license just understand how to use it and understand how to argue it. So if you get pulled over and you go into the grocery store, there's no such thing as driver's license in that point because you're not driving. You're traveling. Where you're traveling to is nobody's business. But the fact that you're not traveling is the only subject matter. But they're enforcing the statutes, which is the public policy, to regulate your freedom of movement. Islam, brother.
Islam. My name is Jure Bey. I'm listening to you talk about the driver's license situation. And that's something I've been dealing with for a long time. And also I'm listening to speak about the commerce and somewhat in short how to operate with it. Now, of course, we know no matter, basically no matter what, they will always
Enforcing black codes.
yeah, in short, yeah, enforcing black codes. Now, I have been utilizing the commerce in short, and I guess I believe it's the straw man
Yes.
situation. And I guess a few months ago, the last time I was in court, it was behind 10 tickets. And what I did was, I told them, explained to them that they had no right. I am Yara Moyama Bey, the owner of the copyright, trade name, service mark of what they were trying to make money on. And that there was a contract.
Yes.
And unless they agree to the contract, they have no authorization to utilize that trademark or service mark.
Right, so possession.
And so, and I said, if so, then you are subject to the contract that I had just presented to Madam Prosecutor, because she had already accepted it. And I said, let the record show that Madam Prosecutor has accepted and has been served notice of such and such and such. And with that, they turned around and the judge said, well, due to the oldness of these tickets, which were only about maybe 3 or 4 years old, and you know they go after people with tickets 25 and 30 years old.
Yes.
But due to the oldness of these tickets and summons, which should have been taken care of a long time ago, we are dismissing these cases, and not by the reason that Mr. Bey is giving, but by the oldness of, such and such. So in short,
dispensation, yeah, in other words.
so in short, it took a long time to get around it, but yes, you can reserve your rights, you can operate within commerce, and still remain sovereign.
Yes.
So that's all. Just wanted to share.
That's great too. And that, conceptually, that is important. And make note on that.
And you're absolutely right. And one thing I want to throw out, being that you mentioned that, there's many ways to skin a cat.
Yeah.
All right? And as we was talking even before the lecture started, you can even beat them up with their own laws.
That's
Or their own policies.
Yes.
Or I should say. They're not laws that they're going by. Okay? What we want to do, and our main charge, is to teach someone who doesn't know. To teach the people. And just like he told you, that we're dismissing this not because of what Mr. Bey said, we're dismissing this because of the oldness of it. Now, that might satisfy the argument, okay? But what it does, it does not set any precedent as far as the challenging of the jurisdiction of the court. Because that became a contract by him saying that we're dismissing it because of the oldness and not because of what you're saying. Our argument is you have no jurisdiction to proceed. This is an improper administration. Improper meaning it's not constitutional. Regardless if you copyrighted that entity, that straw man,
Yes.
regardless if you copyrighted or not, those cases are fraud on its face and
Yes,
should be
they are.
dismissed.
Yes, they are.
So the moral of the story in brief is, if there's other people in that courtroom that's not conscious of their birthright, of their nationality and birthright, they might sit there and don't know about this copyright claim you have, and they might pay the ticket after you.
That is
So theoretically, that keeps us as a nation stagnated, because the whole moral of this movement is for the upliftment, to teach one, to bring everybody up to a certain vibratory rate. So the usurpation and the color of law will be neutralized, and then it will be returned back to the hands of the sovereign by forming that plebiscite. But the only way that can be formed is if the people have information and the people are equipped on knowing how to fight those traffic tickets. Because the traffic tickets is the main deed that they're using for the debasement of the human mind. And it has nothing to do with color or nationality, because everyone is subject to it. And like we said, there is a lot of patriots, a lot of Europeans out here fighting de facto colorable public policies. And if they're fighting, it's definitely our obligation to fight it.
I definitely agree with you on that point.
Of booty and prize in the traffic courts of commerce. Am I correct? That's what they've been operating.
Yes.
Therefore, the argument that you're making, in which I agree with you, where they've been moving forward anyway, or claiming a jurisdiction in spite of their obligation to common law venue, under the War Powers Act, denying it, and therefore seizing a jurisdiction under Admiralty. Well, the Congress said in the Admiralty jurisdiction, the venue is district court. What does that state for you? That they still don't have jurisdiction. Now, understanding that the Admiralty and maritime jurisdiction therefore makes it a military tribunal. We really understand that. Therefore, it is also a presentable argument before the court, due to the fact that it is indeed booty and prize, that those persons claiming authority, back to the DOAO principle, now they have to show cause in the court that they're holding a military trial in an ordinary civilian court. And that argument should be made, not just with the straw. I'm talking about, these are things that we already know.
Yes.
But not necessarily arguments that we presented to the court in evidence. Not just the argument of delegation of authority order, but the conditions, even if it were met. Even if all the conditions are met to justify the color, the jurisdiction remains district court. And in district court, they have to present themselves in their military garb. I just want to throw that at you as an argument.
Yes.
And I think too often that we don't, while we know that we don't take the opportunity to seize that as a presentment in the argument after they seize jurisdiction, denying a proper venue, i.e. common law, constitutional venue, by which the judge, before that court, has already an obligation, sworn oath, that you also introduce into court. I want to make that point.
Point well taken.
Yeah, consider that too.
As long. And one other point I want to make on that is the argument that you made in the courtroom actually did dismiss it. He just said that wasn't the reason. Which they're not going to never admit why they're dismissing it. They might say the cop didn't show up. They might say any excuse.
Right? Yeah, true.
But being scholars, we know why they really dismiss it. They don't want to touch it. But what it does, by him saying for the record that the reason why he's dismissing it is because they're too old, and we don't object to that, creates another contract. Which means that we do agree that he does have jurisdiction, but he just can't pursue this one because it's too old. He just got our agreement with that. Now, forbid if in the future, if any other traffic tickets come up, now we start off fresh again. Now he's not old. Now we got to go toe to toe
With the colorable jurisdiction.
because there wasn't no precedent set the first time. He might not, you can come at him with that same argument again, and maybe he's not gonna want to deal with it no more. But the whole moral of the story is, now he has our agreement that he does have jurisdiction over the subject matter. And the person jurisdiction.
Well,
Under those conditions. In other words, now, let me make a comment on that. I'm sure you got his point, but I want to make a comment on this. And this is the point where we were talking earlier, where you make it very clear. Then you bring up the document. Bring up the document of the War Powers, where Congress established the jurisdiction of the booty and prize, which of course you know is what that court is seizing. The booty and prize bring up the distinction of the specificity of the establishment of the jurisdiction being solely District Court of the United States.
Yes.
So, and whereas the judge had claimed that it is due to the age, in other words, he didn't really say, he's implying a statutory principle of that it passed some statutory code for enforcement, etc. That doesn't preclude the fact that the suit is originally a suit anyway. That a summons and the tickets is a suit.
Exactly.
And then while they issued those suits, that they did not advise you on any grand jury indictment, etc., which also didn't give them jurisdiction even in that color. Because since the Commerce Court of Trafficking in Commerce, which is what that is,
yes.
and the summons to that is a breach of contract in commerce. All right. So they technically, the reason why it's listed in quasi-criminal because they accused you of theft. So they accused you of theft of a service for which you did not compensate them.
Yes.
All right? So that's what a ticket is. An accusation by the corporate court of accusing you of stealing a service from them and not compensating them. However, what they called a service that they accused you of stealing from them, no one made an indictment. Therefore, the claim before the court is invalid on its face. Because there was no official accusation or proof of substance or a thing stolen. So being what they call the traveling is technically, in its principle, an abstract. The doing is a thing, but the principle is an abstract. It means it's not a physical thing itself that can be handed to you in a package. All right, traveling.
Okay.
All right. Due to the fact that the right of travel pre-exists with the person as a natural and divine right, having nothing to do with government whatsoever, which was already adjudicated by the Supreme Court on a multiplicity of times as being a right that cannot be interfered with by states, city, police officers, etc. How did that right be classified as the property of a private state, corporation, to by any implication being sold to you that you breached and then they accused you of theft and therefore suing you by that ticket without a formal indictment? Because the Commerce Court is a court of commerce and trade, which is why it's called traffic court. Right? So we understand this.
Yes.
So now, due to the fact that the quasi-criminal court is an admiralty jurisdiction, therefore military, it must be issued or also stated in any documents they send to you that it is a military tribunal, but it's operating in a civilian court, funded under civilian jurisdiction, with city management funding it from taxes from the common people. Right? Which we already know this is. All right?
It's fraud all the way
Now,
around.
you know it is, but
Yeah.
I'm looking at what is the obligation of the citizen before the court relative to the delegation of authority order that you demand of that person that's issuing that tribunal that suit against you, i.e. the prosecutor, and then usually the judge acting also as a prosecutor in violation of due process. We already know that. But we also know that because it's a military jurisdiction with admiralty law dealing with booty and prize, that the defendant before the court, by their rule under the color, has no judicial standout.
Yeah.
And therefore, any obligation on the part of the court to recognize constitutional due process is voided necessarily by the judge simply stating so, meaning that don't bring that constitution into this court. All right,
Exactly.
fine. However, you do already have in your possession a copy of the oath and obligation that judges take to uphold the Constitution. Am I correct?
Correct.
And you know that the jurisdiction between civilian and military are separated by by powers or separation of powers in government. Am I correct?
Yes.
Executive and judiciary, etc.
Yes.
Right? All right. Therefore, what you would ask the judge is this. I have in my possession this document where in the law of admiralty of booty and prize, which is my property that you said that I violated a service that you were selling or that belonged to you originally, and that you're claiming that I have an obligation to compensate you for as the holder in due course relative to this issue. And even though you present before this court an issue or an argument with this nom-de-guerre, or the straw man, this Negro, black, and colored straw man, etc., whatever you want, whatever the straw man may be, you can qualify it for the record. Well, the Congress of the United States that caused this war power authority to exist, by which you're claiming of bringing this admiralty law on the land, states that the jurisdiction for such a dispensation on the booty and prize is district court. Is this a district court? There it is for the record. Congress of the United States state that the jurisdiction for the booty and prize, upon which they deal in these statutes, is district court. Now, is the traffic municipal court district court? I'm asking.
Oh, no, it's not.
See what you can ask the judge?
Exactly.
I mean, you already know this, but I'm just saying, look at the battle or the grounds that very often people have that they don't run to.
Right.
That even in the colorable jurisdiction that they're operating in, they're still in the corner. But what happens is, though it is a known factor, people are arguing the common law venue, which is proper because that's where their obligation is.
Yes.
However, even if you weren't making the argument of the common law venue, which is absolutely correct and proper, that in their colorable venue, they're still locked into the original jurisdiction in booty and prize, remaining with district court alone. Which means you can't even agree, and they can't take, even under color of law, the jurisdiction that remains with district court, even under the issue of no judicio standi. And so, inclusive of the argument being made with the man of straw, contractually wise, with no copyright, etc.,
Right.
that superseding that they have no jurisdiction in the personal matter, still, even if out of ignorance you agree to it, if you didn't even know anything about birthright, if you didn't know anything about color of law, that they still don't have the jurisdiction even under statutory codes, but the statutory codes under admiralty and booty still states jurisdiction, district court, United States. I just wanted to hit you with that. Keep that in mind. And also, in your future cases, make up affidavits applying that. Go into the War Powers Act and deal with the code of the issue of jurisdiction by the Congress dealing with booty and prize.
Most definitely.
Another thing you want to keep in mind is, like I was saying, their administration is improper, which is that's a lawful term. It's called improper administration. Now, I'm going to read it. Not suitable. The first definition it gives. Not suitable. Now, we know that traffic are suits. Traffic tickets are suits. That means they're suing you. That's one of the reasons why it's improper. They said it's not suitable. Unfit. Not suited to the character. That's the main key. Because anytime a Moorish American enters those courts, the first argument should be diversity. And that was in the nature of what Grand Sheik Taj was speaking about. It's automatically diversity of jurisdiction, and diversity of citizenship. Meaning that those tribunals, due to the Inquisition, have been colorably enforcing unconstitutional laws and trying to get your agreement under fraud. Making you think that it's a breach of contract. That's why they're bringing you there. In your reality, you're thinking that you've done something wrong, that you need to pay according to their corporate policy. It's fraud, because they never had any right to turn your exercising your right into a crime. And by them doing it under color, and even like you said, even if they might have got your consent, being that it was done unconsciously under color, it's automatically null and void, which means that they don't have jurisdiction. So based on diversity, under Title 28, 1332A of the Federal Civil Rule Procedure, that clearly explains that the federal venue is the proper jurisdiction of that situation, based on the character, the status, and based on diversity of jurisdiction of the venue. So it's different ways why they don't have jurisdiction, but those tribunals are not suitable courts. Even Supreme Court and the federal venue, the federal courts, the district courts of the United States have exclusive jurisdiction in all civil matters, as well as criminal. So even if they're bringing suit or claiming to bring suit, it clearly states that federal court is the only jurisdiction where the suit can take place. And they're never going to tell you that it's a civil procedure, because it's not. And if they do tell you it's criminal, then where's the indictment at? So that's another reason why it can't be, a suit can't be brought in that court.
Exactly.
Because you don't have an indictment, and it's not civil. The whole thing. District courts of the United States, each having territorial jurisdiction over a district which may include a whole state or only part of it. Each of these courts is presided over by one judge who must reside within the jurisdiction. These courts have original jurisdiction over all admiralty and maritime causes and all proceedings in bankruptcy and over all penal and criminal matters cognizable under the laws of the United States. Exclusive jurisdiction over which is not states, exclusive jurisdiction over which is not vested either in the Supreme or Circuit Courts, also inferior courts in Colorado, Idaho, Iowa, Kansas, Louisiana, Minnesota, Montana, Nebraska, Nevada, New Jersey, New Mexico, North Dakota, Ohio, Oklahoma, Texas, Utah, and Wyoming are also called district courts. Their jurisdiction is for the most part similar to that of the county courts.
Now, let me make a comment on that. Therefore, even with the bankruptcy, with the issue of Governor Roosevelt, March the 3rd, 33, when he asked for the war powers before he was inaugurated as president, upon which the color of the bankruptcy of the courts, of the banks of the United States, lawful certificates for money is concerned, and whereas they brought in this argument for the issue of the admiralty and maritime law, correct? As you can see, this is the law. The jurisdiction still resides with the district courts, which means, again, the traffic courts are invalid. They're proper administration. We already know they are in their moral and ethical principle. We already know that. We always make that argument. And then, of course, you've got the diversity of nationality, diversity of citizenship relative to Moorish Americans, which is why Noble Ali nationalized the Moors, to get them out of that color, you know, and for the Moors to study and begin to understand what their position really was as opposed to what they thought it was. But beyond that, even within the color, you can see that in the admiralty jurisdiction and in the maritime jurisdiction is still only district court. So the municipalities, even of the states, or even of parts of the states, have no authority to call that jurisdiction into their venue. it's still an improper venue. However, the implication that you're making a contract with them by not objecting, as Grand Sheik Nature was talking about earlier, even with the judge saying, i.e., that he didn't dismiss those 10 tickets based on the argument that was made by yourself, Yahweh Bey, but by the virtue of the statutory codes, the age of the tickets, of the suits, etc.
Right.
Which was a way to let himself out and let you out.
Yes.
But at the same time, he was still stealing the birthright of everybody else who was sitting in front of that court.
Yes.
You see? And so the issue that Grand Sheik Nature is saying, which is most valid, which is our obligation being Moorish Americans, is to help uplift fallen humanity. So even at the cost of you yourself going to jail, your duty is to still preserve the rights of the people.
True.
Meaning that say, I object. The issue is not the age of those suits, for you know those suits were not prosecutable anyway, because the jurisdiction is invalid, and here's the evidence that even under Admiralty law, the jurisdiction is still district court. I state for the record, and I present this question to the court, is this a district court? You don't have to tell me, I already know that it is not, and you know that it is not. So we're not even going into your DOAO, or even identifying yourself, showing whether you are a citizen of the United States of America, which is jurisdiction, because you're definitely not indigenous. Therefore, the only way that you would have any authority whatsoever would be your obligation and your oath to that Constitution to which you are bound. And every judge in every state is bound hereby. And being me, myself, Moorish American, indigenous to this land, being part and parcel of this said government, being in propria persona, and sovereign, and of the people, command you, the servant, to uphold your obligation. Forget the matter that you're claiming before this court. First, you have not established and presented yourself. I'm presented, and not represented. Presented. Now present yourself. Are you a body or personage in the military service of the United States government? And if you are, introduce that into evidence right now. If you cannot do, dismiss this whole thing and pay me for the time that I've been here. And this is back again to the straw man. You say, I'll be receiving my bill. And send them a bill. In spite of their operating in color. You know.
I just want to share this part with you. There is about 40 different suspensions that they have a good, and I recently just messing around, went on the internet and was looking to receive a copyright trade lawyers and whatnot, and sent them a copy of my UCC financial statement.
Yes.
They're eager to go after it because it actually adds up to be a $20 million suit.
Yes.
And that's $500,000 for each time that they use the service market trademark.
Yes.
But again, you know, you look at it one way, you don't look at it another way. You look at one way with an individual win, whereas it should have been carried further to be a national win.
Now this is
so,
you're correct. Now, and see, with all the redundancy in some of the work that we're doing, this is the consciousness that Noble Drew Ali was bringing to the people who know law. And he made a place for everyone in this movement. You even have some Europeans in the movement. You understand?
Yes.
The importance from a political perspective of COINTELPRO and the agents that came into the movement to overthrow the movement was the realization of what he was really bringing to the people. For it is through that the lost estate must be reclaimed.
Yes.
See, so it's literally that you have to literally choke the straw man rather than seek an agreed on board trustee benefit of the straw man.
Yes. Because it's fraud by faith.
Yes.
And to get the fraud out, the truth is fraud.
The truth must be told. In other words, like this. what occurs essentially, and this is basically what happened in that dispensation. While it may have given you pseudo remedy as an individual citizen, meaning he acknowledged your birthright as an individual. In other words, what he did, toss you 30 pieces of silver to let your brothers and sisters still be hung. If you understand what I'm saying.
Yes.
While that was your right, it was not an offer in the sense that he was giving you something as a bribe, no. But he was letting you kill, like Grand Sheik was saying, kill the suits, which you had right to do regardless of what he said, without even arguing the straw man, because of improper jurisdiction and improper venue, it is not prosecutable, but you must state that it is not.
Yes.
You know, anything not stated is waived in a military court where no judiciary stands. So this is back to even where the principle, even though a lot of people were later to really understand what he was saying, why Noble Drew Ali said, if you don't do anything else, declare your nationality. And you must understand what it really means to someone who's operating from an occupational position, not necessarily just from people who receive the information, but from someone who's operating government from an occupational position. He recognized that the sovereign has spoken, and when that is put on the record, now it goes into the international community, not only into the etheric realm. So now you have the angels operating against them now, and then you have the rest of the nations that now recognize you simply because you recognized yourself, not that they need taking immediate action. But what they're seeking actually from you now as the individual who's taken on that sovereign statement is now to reach your hand back to your brothers, who keeper you are.
Yes.
I.e., which is the unity that's listed at the post, at the top of that charter that Noble Drew Ali has on the wall saying Islam, Allah, unity. Then you must understand that grip again. See, all these things are there, even though they're put there, they're put down for now. So you have to remember when those things are presented to you or before you as an argument before these courts, which are tribunals, to have stolen this. So it always goes beyond the individual, and you must always recognize it as such. Not that you didn't, but I'm pointing that out. So always remember that even under the Admiralty jurisdiction that they have an obligation, the venue still remains with District Court and L. So, now what? You see the point?
Yeah.
So so even when they adjudicated in District Court, now you command that everyone of the members of the military in service to the nation present themselves. What's your MO? They ain't got no MO? Then not the sheriff, federal marshal. Go get them. See, so what you want to do, you want to paint the paper trail, even in the district level, that you are now painting on the civil municipal level, which is where we're beating them up, which is why they're starting to oppress more. In other words, they're oppressing more because the system is falling apart. So when you look at them oppressing more, don't look at it as failure. It's actually success. Because when they were at the position where they thought the Moors didn't really know what they had, they wasn't worried about the Moors. They're worried about the Moors now because the Moors are beginning to understand the truth about nationality and birthright, what it really is. Because the power, political, is behind that. And so therefore, the only thing that has the U.S., i.e. the demons in power, now, is their military machine, which is why the military courts. Now, the only thing that maintains power for and because is because the Asiatics keep on fighting the wars for them. They can't win the wars by themselves. Therefore, it is in your best interest. And remember, the crusade, what is the crusade pledge? The crusade pledge against the Moors is this: